Bismillahirrahmanirrahim. They say that good things come to those who wait, and on account of heavy rain, flood conditions, we made you wait a long time. So I'm sure that the lecture and the training that we're going to have for you today is going to be an exceptional one. It is indeed a privilege and a pleasure for us to welcome Madam Catherine Drummond, barrister, an Australian barrister, Cambridge PhD, as well as King's Counsel, Mr. Tariq Baloch, barrister, Oxford, Harvard PhD, and with a host of actually qualifications and exceptional practice of law in the Punjab Bar Council today. At the outset, I must thank Barrister Nudrat Majeed of 4 Golf Roads Chambers as well, who has actually collaborated with the Punjab Bar Council to welcome these august guests before you today as well. So without much further ado, I hand over to Barrister Nudrat Majeed. Thank you, madam.
Thank you very much.
You could please, if you want.
Yes.
Thank you.
There. Karim sir, would you like to
I'll join you shortly.
All right. Assalamu alaikum wa rahmatullahi wa barakatuhu. Thank you for making the effort. You know, like Qayyum Sahib said, good things come to people who wait, but also the Prophet of Islam said, go to China even just for knowledge. So that is the importance of knowledge.
Just switch it off. बंद करो उसको. बंद.
हाँ बस वो बंद ही रखें. अब थोड़े से लोग हैं, I think even without, this is the first test of advocacy, right? If your audience can't hear you, then stop practicing advocacy and become a corporate counsel. There are many things that one learns in travel and education. And one of the best things that I learned in my travels for education was how much importance is given to teaching others and to learning in the West. It always used to inspire and motivate me that people would spend huge amounts of money just to attend one lecture. And that's the value of education that our culture also has been taught. So first of all, I would like to thank Punjab Bar Council, especially Barrister Qayyum Sahab, who at such short notice collaborated and cooperated so much and gave us this chance to participate in activities of the Bar Council. Thank you very much for that.
Honor for us.
And we look forward to starting a series of collaboration with you. So thank you very much for responding so swiftly. And secondly, our guests today are here for a matter of hours, not even a week, because their practices are very busy. They both have international practices. They are in Lahore for a mere 48 hours, but in those 48 hours they agreed, and in fact were very happy to come and share tips on advocacy and their journey into the law with us. So I'm very grateful to both Catherine Drummond and Tariq Baloch. And we'll get straight into it, because what we really want is for you, and I would like for you to ask questions at any point. We'll have a short introduction by them of their lives, because what we want to know is, why did they choose the law? How did they come to the law? And where did they come to the law from? What was their background? So perhaps I'll start with Catherine Drummond. Catherine, you're from Australia. At which point did you grow up in Australia and do your law and then move to England, and why did you move?
Thanks, Nudrat. Can I just start by saying it's a real pleasure to be here. I'm very pleased to be invited, and I'm looking forward to meeting all of you after the talk as well. So please do ask questions as you have them throughout. So I grew up in Australia. I studied my undergrad law degree in Australia, and then I worked for a judge as an associate for 1 year in Australia before I moved overseas. But my journey to the law started earlier than that. It started when I was in high school. I was about 15 years old, and I was doing debating that we had at school, and often a lot of the topics in debating were on world affairs, and my mother, who was very supportive of me, would notice that I was taking an interest in world affairs, and she would start cutting out newspaper clippings about world affairs and disputes around the world, things happening at the United Nations, things happening in other countries, and she'd leave them on my bed. So I'd get home from school every day and I'd read all of these updates on world affairs. And that happened throughout my high school, and then I got to a point where I started taking more of an interest in world affairs. I started doing subjects at school in world affairs, and in particular at that time, in the early 2000s, there was a genocide going on in South Sudan, and I was getting very interested in this, and I was outraged because I saw what was happening in the news, but I couldn't really see any action being taken at the international level by the United Nations, for example, and that stirred something in me that made me think, actually, I want to study this a little bit more. I want to study law, I want to study peace and conflict studies, I want to study what the UN does. And so I went to university and I studied a BA in arts, majoring in peace and conflict studies and international relations and law. And so then the intersection of those two degrees for me was really international law. And so I decided I wanted to do international law. But of course, from Australia, it's quite difficult to do international law. It seems like it's all done in Europe, it's all done in Washington, it's done in faraway places from Australia. And so I sort of did a lot of research on the internet, tried to find opportunities that I could, and I ended up sort of plotting a path to, after I graduated, moving overseas to work in international law, and then also in arbitration once I got overseas as well. So that was sort of my journey to the law.
How interesting. So what we see in life is sometimes, as you experience, that there is support from the family, and that helps us, that creates a path for us. Sometimes it's the opposite, that there is no support, or the family, you are the first person to do law. That's also a very common story. There are what in America are called first-gen students or first-gen lawyers, meaning that nobody in their family ever did law before, knew of law, or supported it, and yet they then made their own path. So Tariq, for you, what was it? Did you have the support of family like Catherine in
Yes.
your journey of the law? Or?
I did, yeah, no, I did. I was very lucky. First of all, thank you, Mr. Kayoum. Thank you all for coming, even though there's so much rain. And, yeah, sure. And thank you also for providing me with a microphone. I was, or I am the son of a proud Pakistani couple. They emigrated to England in the 70s. I was born there with my siblings. And I was very, very talkative guy, loved debating, like Catherine. And it was my father, perhaps being a typical immigrant parent, there was only a few options in his head that were worth doing: law, medicine, even accountant. At one point I thought I'd be an accountant, but I just loved speaking, arguing, and I loved the idea of being an advocate full time. So when I decided to do that, I was very lucky that my father and mother not only supported it, but they supported education generally. So it's quite funny. He did not come from a wealthy background or a very connected background, which is why he left Pakistan, let's be very honest. But he had an idea of education which I feel is sometimes lost today. Because even when I was doing a law degree at 18, he said to me, but that doesn't make you interesting. You need to learn about history, you need to learn about these, that, other. And I say all this because when I then said to him, actually, I've enjoyed law so much, I want to do a PhD, most of his friends said, get him working, let's start earning. And, because my dad's financial position by then had not been very strong. But he was so proud that a son of his was doing a DPhil or a PhD that he never once hesitated or never once showed any sort of, I wish you were working. So I feel very lucky that even if he didn't do it himself, and I would say this to you, that sometimes don't judge the achievements of the person giving you advice. They may actually be the best qualified to give you advice because they know what they didn't do. So I did my undergraduate, I did my master's. I then became a judicial assistant or a clerk to Lord Phillips, who was the Master of the Rolls. And then I went off and did a PhD. And I was encouraged to then become an academic, but I wasn't sure. And then I became an assistant professor at LSE and really, really enjoyed that. But I was missing the element of practice, the real problems that come in practice. And unfortunately, unlike the US, in England, there's a bit of with a lot of practices, there's a bit of a wall between practice and academia. So I decided that I preferred practice more than I did just being a full-time academic. And the beauty of the bar was that you can dip in and out. You can practice and read and sort of write. I haven't done too much of that because you get so busy. But I then became a barrister. I've been practicing ever since.
So both of you, when you were young, you were in debating and you had this dream, and then the course of destiny took you towards the law.
Yeah.
Can you share, we'll start with Catherine, that when you are law student, your image of what you're going to do with the law is very different from when you actually start practice. So could you share with us that as a law student, what did you think the practice of law would be, and when you actually started practicing as a barrister, when you qualified, what were the main differences that now when you look back you think, oh, I wish I could tell students that when you practice, when you're studying, prepare this or be mindful of this, because when you will go into practice, you will need this. What can you share any tips or points?
That's such a great question. So when I was a law student, when I was getting interested in international affairs, I wanted to do international law. I thought originally I wanted to do international criminal law. And so then I got work experience in domestic criminal law. I went to Tanzania and I worked for the UN International Criminal Tribunal for Rwanda for a while. And I thought after that, when I left and went into practice, that I would be on my feet all the time. I would be in court all the time when I was practicing. But in fact, and it does depend a little bit on the area of law that you practice in, but if you do big international cases, big commercial cases, arbitrations, for example, it's a lot of sitting behind your desk doing paperwork. But that, I don't say that as a bad thing, I say that as a good thing, because you need to be really prepared to do these big cases. A lot of the time they involve lots of complex facts, lots of evidence, lots of law, and they go on for years at a time. And so you need to be really methodical and organized in your analysis, in your note-taking, because you might have a case, and this has happened to me on many occasions, where the case has been going on for years, and something will come up, and you'll think, I did look into this like a year ago. What did I think about it? What did I read? And if you don't have a good set of notes that you can go back and look at and say, this is what I read at the time, this was my analysis, this was my conclusion, this was my advice to the client, then it really sets you back. So if I could give my younger self advice, it would be mindful that in practice you need to be methodical, analytical, and you need to have really good systems for note-taking, for record keeping. And that will help not just you in your own cases, but it will help the people, and particularly the more senior people that you work with. And it is a really good way to impress senior people that you work with. If you are a junior on the team and you are organized, you can show that you've thought of all the possible parts of the analysis, you've worked through it, you've presented, you're thinking in a really organised way and that you can provide that analysis to people on the team to help them. Because ideally, when you're working in teams, and often even though barristers do work on their own, they often do work in teams, teamwork is so important, not only for the effective management of the cases, but also because people like to instruct people that they like working with, and teams work more effectively, clients get more effective outcomes when teams work really well together. So, yeah.
Very, very, very useful. Very useful. Tariq,
But
your
yes,
experience?
I think, yeah, no, this is all great advice. I would say two things that, the way I'm going to look at it is to tell you two things that perhaps are not immediately obvious, or three. The first is it's not a race. When it comes to reviewing material, you'd get long lists. And the breakthrough for me was, I remember a teacher who I'm very fond of, she said that I had to read this a few times. And I was like, oh, really? It's not embarrassing to read something 2, 3, 4 times? And I would deeply encourage you, it is not a race to understand something. And often you may go back to the same article and understand it differently. Secondly, embrace self-doubt. If you don't have any self-doubt about any argument you're making, you're doing something wrong. You're overconfident. And I remember a judge once said to me about another lawyer that he did not have enough self-doubt, the lawyer, to be a good judge. And just reflect on that a bit, because, and this brings me to my third point, which is, it's not just about the positive case that you're going to craft. I always write another document setting out all the difficult questions I think I'm going to get and try and map out my answers. I spend more time on that because even when you present your positive case, you get so many questions that you're never going to get a flow, sort of a free-flowing, oh, here is what I'm going to say. And that preparation of all the questions you're going to get and the why and having the self-doubt and not thinking the other side is just stupid because they're just your opponents, but they may have something interesting to say, and why are they saying what they're saying? Let me just not dismiss it. Really shows in a good advocate's work, because the way they answer questions, the way they're prepared, and the way, even when you're presenting your positive case, you will proactively take them through the obstacles that the judge may have. So think about what the judge wants, what's helpful to them. Think about why the other side is saying what they're doing and how that impacts your case, and are there any weaknesses. Don't forget to think about those perspectives. So make that shadow document. Don't just put your positive case. If you have time, I appreciate you're busy. If you have time, make that shadow document about all the difficult questions that you think would come.
That's very useful. Thank you for that. It feeds into this whole subject of case management. Now, here in Pakistan, we think of case management in relation to judges, because the judge, when they are apprised of a case, they will then manage it for the hearing schedule, what they want to hear, framing of the issues. But when you're doing work like yours, which is a lot of international work, and as you said, that you're working with different and sometimes very large teams. Yeah. And so you're not only managing a case, but in a sense, your advocacy starts first with your own team before you start advocating in front of a judge or an arbitrator. So how do you then manage the emotional quotient to be an advocate with a team, and it may be cross-cultural? So just to share with you, both Catherine Drummond and Tariq Baloch do vast international arbitrations that involve millions of dollars, and often they will be over different jurisdictions. They are here in Pakistan right now because they are counsel for the government of Pakistan in a number of, there are multiple arbitrations happening. And so they're managing not only people from different cultures, but advocates from different cultures. So advocates who have their own strong opinions, they have to work with them. At the same time, they're managing different legal systems. So they have to then also manage the English, if English law is applicable, they're here in Pakistan. If Pakistan law also has a role to play, they have to manage that also. So in terms of case management, you've shared a bit about how to personally manage and the note-taking and being very methodical in these big arbitrations that you do, because arbitration now has become the most fashionable field of law. Every lawyer wants to be an arbitration lawyer. Of course, it has very lucrative returns, and it involves a lot of travel. You meet people from different places, but one of the things I feel people forget is how much more technical you have to be than if you were just working in one jurisdiction, because of the fact that they may be competing legal systems and frameworks. So how do you do case management in these kind of large arbitration cases?
Being very organised is my number one tip, in terms of understanding what the case requires procedurally, what the steps will be, planning ahead for each of those steps and what they will require, making sure that everyone on the team understands what is expected at what time, and that the tasks are divided in a way such that everyone can work effectively to that timeline. But in terms of what you were saying at the outset, working cross-cultural teams across different jurisdictions, that's also a really important part of managing the cases, and it's always important to have respectful and open communications with all members of the team so that everyone can share their input on the cases, because it's so valuable to have different perspectives giving input on different aspects of the cases, and it's important to understand where the strengths in the team lie. For example, the Pakistani lawyers that we work with on cases involving the government of Pakistan, we know that their expertise is in Pakistani law issues, and so we defer to them and we ask them for help and we listen to their guidance and we take that on board in relation to the Pakistani law issues, and they do the same for us in relation to the English law issues, and so in that way we can work very collaboratively. And then on the issues that aren't specific to our legal systems, we both have input and we improve each other's thinking by sharing ideas, bouncing ideas, testing theories, seeing if it would work or not, anticipating what the other side, as Tariq said in terms of the shadow document, we often test each other's assumptions, we play devil's advocate and see what would the other side argue and what would we respond. So all of those sorts of collaborative ways of working is really crucial to building a really effective, not only team working manner, but the best possible case for the client.
Tariq?
Yeah, I agree with everything Kat just said. Again, it's part of the self-doubt thing that you shouldn't assume that your system is the best and only way of doing things. I often find, unfortunately, barristers are the biggest culprits when they confront other traditions. They can come across as a bit arrogant because they think that the common law method or the English law method is the only way. And I think one has to be open, that there are different approaches to dispute resolution, and informed by that open attitude. The thing that a good lawyer should do is not even know lots of the law because we can go to the books. It's not a memory test. Is to ask good questions. If I had to say that for me is one of probably the qualities that a good lawyer should have. And so when you are investigating a different legal system or a different legal culture, being ready to ask those questions to really comprehend where the issue is coming from does two things. One, it means that you are really engaging with the subject matter properly that's different to yours, but also your client is not just the industrialist or the company, it's the local lawyer too, right? And being felt that they're being heard by you because you're taking the effort to understand the nuances is really important. It's a very big role we play as therapists as well. So I think having some self-doubt, being open to different ways of doing things, and genuinely curious and inquisitive, I think makes you a far more effective international practitioner. And having no preconceived ideas that my way is the best way.
And just in relation to that, in arbitration in particular, it's important to try and put yourself in the shoes of all the other people in the case. So not only the local lawyers in terms of what is a Pakistani law perspective on this issue, but also the arbitrators often will come from a different jurisdiction, their own legal culture and own legal background, and so you have to put yourself in their shoes as well. And sometimes you might have a panel of 3 arbitrators from different civil law, common law, other sorts of legal systems with different training and different experiences, and you have to try and anticipate how each of those people will see the issues in the case. And so taking that on board as well is good. And training in terms of in your team when you're having open collaborative discussions with members of your team, putting yourself in their position as well, is good training for having an open mindset, for needing to do that for the arbitrators as well, or the judges on the bench of the court that you're appearing before.
So what I got from both of you is that communication skills and just the art and ability to communicate is critical for to be successful and just for to be a good lawyer, and the humility. And I personally also seen that because I practiced for the first 10 years in England, and it was interesting to see that the top barristers were the ones who were most international in their perspective. And being international in perspective means that they had what Tariq and Catherine are saying about self-doubt and questioning constantly. They never assumed that their way was the correct way. And that I saw would set them apart from other barristers who technically were very sound, but they weren't open to different perspectives or a different view. And that I think is very critical. So again, it comes also to advocacy, and I would like to link it now to the role of the Bar Council in England. Since we are here in the Bar Council, what in your view, or have you had experience where the Bar Council in England helps you develop these communication skills or advocacy skills? Or is it something that you have learned because you were lucky enough to get good mentors, or you were lucky enough to be in good chambers? But what is the role of the Bar Council?
The Bar Council in England and Wales is really critical for continuing legal education of all barristers in the UK. So there are requirements that we have to meet every year in terms of the number of hours that we have to prove that we have participated in lectures, seminars, training courses to further our own legal education. And that requirement is broken down into different categories. So we have a certain number of hours we need to do in advocacy training, a certain number of hours we need to do in ethics training, and then a certain number of hours we need to do in other sorts of substantive furthering of our knowledge in our particular practice area. And so the role that the Bar Council plays is not only setting up the courses that allow us to continue the education, but also monitoring that the barristers are complying, because it's so important for the Bar Council to hold the bar in England and Wales to such a high standard, because that is part of our professional reputation, and it's part of building a really strong bar that has a strong set of ethical rules that everyone complies by, and everyone continues each year to further their education to be as best as they can. So it does have a really strong and prominent role in the life of a British barrister.
Yes, I mean, look, it lobbies the government for better conditions, because the criminal bar is really suffering in England. And who best to understand those joint interests than a body that represents you? It has an education function, as Kat said. We have to continually make sure that we are exposing ourselves to learning, making sure we're learning beyond just our practice. And it has a regulatory aspect of not breaching code of ethics, which it takes very seriously. So people can complain, or you could be reported, and then they can investigate. So I think it's very important, and I'm so glad to hear from Nudrat about what the Bar Council does here, and the BVC course that you've set up, which I think is, in England, as Nudrat was saying, you used to not even have law degrees. You would, because that was looked down upon. A man, and unfortunately it was often men, where the man of letters would be someone who did the greats or the mods. They'd have a good language, and then they would go off to the inns, eat a certain number of dinners, and then pay their pupil master to train them. That is not very open to social mobility, because you need the funding to do that and have the connections. So I'm very glad that things have changed, that you have a bar course. It's probably too expensive, but there's scholarships or money from the bank you can get. And you're doing the same thing here. So I don't see how the bar can work without a Bar Council, especially because we are all individuals. We're not normally organized, at least in England, around big companies. Yes, we have chambers. So it is really critical that, especially for a profession like the bar, that there should be a Bar Council. So I'm glad to see the role that it plays here.
I'll share an anecdote. So what they're talking, what they both told us about this continuing legal education. Actually, it's continuing professional development.
Yeah.
Is that correct? So it's called CPD. And CPD, you have to get your points. So it doesn't matter if you are the top barrister and are doing multi-billion-dollar cases, every year you have got to attend lectures. And I was first introduced to the concept when I met a judge from then the House of Lords. The highest court in England used to be called the House of Lords, it's now called the Supreme Court. And I met this judge, a lord from, and they were lords. So I met this House of Lords lord judge, and he was talking about the weekend. And I said, oh, so what are your plans on the weekend? And he said, I'm going on a weekend seminar outside London. And I said, oh, I see. Are you speaking? You're hosting? And he said, no, I'm attending. He was 68 years old, the top jurist in England. And he said, I'm attending because I have to get my CPD points. And so I said, who's going to speak? And he said, maybe some 29-year-old, 30-year-old. But it amazed me that somebody at 68 had the humility and the excitement at 68 to say, I'm going to listen to a 29-year-old and I'm looking forward to it because I'll keep learning. So it's a wonderful thing that the bar councils have that requirement, and that enables you to keep your skills sharpened. It's because as barristers, we're all warriors. And as warriors, we can't stop training. And the training doesn't always come from just doing cases. The training is much bigger than what we may face in a case, right?
Yes.
So, yes.
I was just going to say on the CPD points aspect, it's definitely not something that people do because they're forced to do it because they need to get the points, otherwise regulatory action will be taken. The training seminars and sessions that are put on, they're so interesting because you learn things all the time from people who are in different areas of practice, but you're doing the same job, so they have different tips and skills that you might think, oh, I hadn't thought of it like that, and then you'll incorporate that into your practice, and it makes a difference. Or even if it's a subject area that you don't practice in, it's still interesting to think about and learn about different areas of the law, and often I will see connections with areas of the law that I do practice in that I wouldn't otherwise have seen. So it is something that we really look forward to, and I learn things all the time.
Yes, maybe we'll ask Qayyum Saab to start the CPD
But
program in Pakistan.
Qayyum Saab, you don't have to put up lectures. The way it works in England is you could go to a public lecture about law that's nothing to do with the Bar Council organising it, but it improves your education.
Yeah.
And so you just self-report, so you don't have to, and then you can do random checks whether people are reporting properly. So it's actually low maintenance.
Yeah,
It used to be higher maintenance.
Yeah, you can do online sessions.
Yeah, online sessions anywhere around the world.
Yeah.
If it improves your legal, if it's good, and then you just make your own private record of it. It's self-policing. But it's a good cultural shift.
I don't know if you know this, but this is one of my favorite topics, is the whole Inns of Court. When you become a barrister in England, there are 4 Inns of Court. They're like your homes. And so you have to first join an Inn of Court, and then you do the BBC, the Bar Vocational course. What I read, there's a scholar called George Makdisi who wrote about the Islamic College, and his book is titled The Colleges in Islam. In England, the system of Inns of Court, like Lincoln's Inn, where Quaid-e-Azam Muhammad Ali Jinnah went, there's Middle Temple, Inner Temple, and Gray's Inn. Where are you, by the way?
I'm at Middle Temple.
Your Middle Temple?
Lincoln.
Sorry?
Lincoln's.
Lincoln's Inn, like good Pakistanis always will go to where else would we go? Qayyum Saab, where?
Gray's Inn, they say, well, couldn't you get into Lincoln's Inn?
Are you Lincoln's Inn?
I had to be.
So did I. I had to be. But also we have Quaid-e-Azam's picture there. Do you know where the whole Inns of Court came from? They came from the Islamic tradition.
I didn't know that.
So initially what happened was, in the first 200 years of Islamic history, there were scholars, the ulema, who we call the ulema. And the idea was that the ulema should not be affected or influenced by government or by anyone political or by any business. So people were asked to donate money, and there were these philanthropists who would give money, and they would say, you keep these in order to make a scholar, you take them into a inn, and which in Urdu and Arabic is called a madrasa, and they will eat at the madrasa, they will live at the madrasa, and all they will do is study and then test knowledge and throw different ideas to each other. And so the whole concept of Inns of Court came from the schools of Kufa, Medina, Damascus. But sadly, we lost that tradition, but in England, Queen Elizabeth and well before that, they set up that tradition because they saw that this worked so well. And when that student scholar would graduate in the madrasa, they would have to pass under the Quran Majeed. They would hold the Quran and the student would pass under it. So today, you see in the West, and even a practice we have adopted here, is the cap. Why is this cap hard? Because it's on that the Quran which they used to pass under, and when there were more and more students, they couldn't have everybody pass under the Quran, so they gave them these hats which were hard from the top, and they wear these black gowns, which interestingly Tariq will tell us is still called the Ottoman gown, your silk's gown.
Yeah, it is, yes.
It's called the Ottoman gown because it was the Ottomans and the Persian scholars who used to wear the black cloaks. And so that connection is, we've lost it, but they in the West and especially in England, they have maintained it. And that's something that we really should revive because, so just to, before I ask the next question, every winter when we have the gowns, they are compulsory in the high courts. And so come every 31st October, I think the season starts and then we have to wear gowns. And inevitably, in the local news, they will interview some lawyers and say, why do you wear this gown? And majority of the lawyers say, oh, it's from the English because it's a British heritage. We took it from the English. And every time I want to then say to those reporters, no, the British got it from us. But we just have forgotten that this was our tradition. And so it's good that we should reconnect, and sometimes to reconnect we have to go to the teacher. You know, there's a saying that the student surpasses the teacher, as they should. So the Western world was the student of the Muslim world and they surpassed, and now we have to, the teacher has to go back to the student. Ji Manal.
My question is to Sir Tariq.
Yes.
He said one should self-doubt himself.
Could you stand up and introduce yourself so others can also know who you are, where you work, and then please, and speak louder since you're training as an advocate.
Hi sir, my name is Mohammed Nadari and I'm associated with corporate chambers. So my question to you is that you said that one should self-doubt himself as to prepare his arguments. So my question is that how can one prepare his arguments when he's self-doubting himself? How can that he present his arguments to a judge when he's not confident in himself?
Yeah. It's a good question. Obviously, you have to be confident in drafting your opening, but you can't, what I mean by having a bit of self-doubt is you can't just assume and drink the Kool-Aid about how good and strong your arguments are. You need to be very open to the weaknesses and prepare. So be confident, but also realize there may be other angles. And the more you can look at what those other angles are, the stronger your argument will be. It doesn't mean don't be confident. Present what you have confidently, but have enough self-doubt to realize there may be other sides that you need to prepare for.
Let's open the floor now to questions. So any questions, comments, and feel free to ask anything.
I was just curious as to whether bar councils in England are elected, because I'm in my election cycle right now. And
Yes.
whether they are elected.
Yeah. Yes.
And how is it that actually they managed to introduce CPD hours and require already qualified barristers to undergo training as well? Because that is something that we get the most opposition in Pakistan.
Yeah.
I mean, we have started the bar vocational course, which is a drop in the ocean. It's only 2 weeks. We have made our best efforts to actually have that implemented in the last 4 years, but there is absolutely no, it appears, willingness for anyone to undergo further continuing legal education, especially if their license is going to be actually dependent thereupon. So in England, was it introduced by the same elected officers or was it done through legislation? And what would be the appropriate way
good-
to,
it's a good
that is
question.
something we wanted to introduce,
Yeah.
but I'm quite sure that
It's a good question. I think it was introduced by the regulator, the Bar Council, rather than legislation. But I can get you more information and even introduce you to people, because I've been on some Bar Council trips, for example, to Kenya. They're very keen to build relationships and share their learning and how they do things. So if you haven't done that already with the Bar Council, I'd be very happy to put you. They have an outreach and international officer. So my impression is that it was passed by the elected body. They are in charge of regulations. They update codes of ethics. They will change codes of ethics. They have subcommittees, and they will condition it on our requirement to. Every year I have to renew my practicing certificate, and every year as part of that, I have to tick a box which says, did you do the sufficient number of CPD hours? And it's policing, it's self-policing, because I just declare it, and of course I could lie, but you hope that people don't, and you're supposed to keep a note of the things that you've done in the year, and they will randomly audit. So point one is that yes, it's elected, the council is elected. They have a permanent staff that obviously they don't elect them, they sit underneath. Two, I think the CPD is something that the regulator has introduced rather than legislation, and it's conditioned on a license, and it's really random checks that they enforce it through.
it's not voluntary, it's mandatory.
Yes.
Thank you.
How is the Bar Council funded? Are they
Contributions by us.
corporation
It's part
or
of part.
contributions to the members of the bar?
Yes. When we renew a certificate, the price that you pay is based on your earnings. So you have to declare, as part of the renewal of your yearly certificate, what were your earnings in the year, and depending on what they are, you pay more if you earn more, and so that's one way in which they do it.
So it's on percentage.
It's not very big. I mean, it's small,
Right.
but that's how one way in which they get contributions.
And they also get, I'm sure they get some government funding.
They get some government funding too. Yeah.
But that's very good, because if it's by contribution, it gives you a degree of independence from government or other
Yeah.
pressure groups, I suppose, because then it's just you're self-sustaining.
Yeah.
I see. Any other questions? Yes. Please introduce yourself.
My name is Nudrat Majeed, and I'm final year student at Government College University Lahore. And my question is from Dr. Saab. How do you see the tension between the local arbitration systems such as Jirga, Panchayat, etc., and the ADR? Additionally, how ADR can incentivize the rural population of ADR instead of their existing arbitration system, such as Jirga?
What was it? Jeddah or what?
So Jirga, you'll have to explain what the
I think the
concept is.
Panchayat, I understand. So your question, I imagine the other one is also, it's not within the formal sort of arbitration, mediation, it's outside it. Your
Correct.
question is, how can you encourage it, or the relationship?
Yes. There is I can say there is a resistance from the rural population of the ADR, because they are not familiar with the ADR.
Yeah,
Yes,
okay.
they are already have their own system,
Yeah.
dispute resolution.
Right, okay. Well, look, I don't think, I haven't thought about this in great detail, except this is not a new problem. I love legal history, it's what I did my PhD in. And there's a lot of really good work written that even when India, Pakistan were the same, in the British Raj and even before, they had a very developed system amongst communities to resolve their disputes. They were either very informal, like the Panchayat, or they were a bit more formal, but not as formal as arbitration, like communities. Certain religious communities, the Boris or the Parsis, they had their own way of resolving disputes. And it was very successful because, and in England even, if you can call it that, cotton traders and people like that, they didn't go to formal arbitration. They had non-lawyers resolve their disputes amongst them because they understood the commas better. So I suppose what I'm trying to say to you is that I don't see a tension between the two in a way that would make me think I don't like Panchayat or I don't like this other system. I think they should go ahead if that makes them comfortable. All I would say to them is that there are certain things that are advantageous about arbitration / mediation, and it's really enforcement. right? If you want to actually then go and enforce against property because the other side isn't paying, and you want to get something concrete, then you may want to consider a more formal mechanism that feeds into the court. Because I don't know how panchayats work. I don't know how easy it is to enforce anything if it's not within the community. So I would stress some of the advantages. But, I come from in England, they are really increasingly encouraging mediation. So they don't think arbitration litigation is the only answer. They really want people to mediate and resolve their disputes in a non-contentious way. I don't think that necessarily answers I don't know if it answers all your question, but I don't see it as a tension.
So, Niyamat, where Dr. Tariq is coming from also is, I see you are coming from a position where for centuries the system has been Jirga Panchayat. And now this ADR it's a statute.
Okay.
And so it's seen as something imported from out abroad. It's foreign.
Yeah.
It's not homegrown. And when you talk about enforcement, actually the Panchayat Jirga system are extremely efficient in enforcing. So what abroad they are now saying that we started with that, with this community dispute resolution, we then moved to more institutional organized mechanisms, and now we've seen that actually we have to go back and incorporate that into the new institutional system. So as Dr. Tariq says, they don't have to be in conflict. They can work together, and they should work together because that's the most efficient way. And we'll ask them the same question. Let's pose to Catherine, because you said that you worked on Rwanda, the genocide in Rwanda. So Rwanda is this country in Africa where there was this one of the biggest genocides that took place over a period of 3 months. I think there were 9 million people, or in 3 months they were killed. But the way they reconciled, their whole reconciliation system of dispute resolution was very interesting. So let's ask Catherine, did you have any experience of the dispute resolution, and did you see the community with UN or institutional frameworks?
So you're right, there was a local dispute resolution court system called the Gakaka courts, which were operating in Rwanda, but that was separate to the trials that the United Nations was doing of the sort of senior leadership figures. So I was working with the UN system, so I didn't unfortunately get a chance to
But you saw that they were both.
But they were
Yes.
working in tandem because, of course,
Yes.
because there were so many perpetrators, because it was a genocide that erupted along ethnic lines, the two main ethnic groups, the Hutus and the Tutsis in Rwanda. There were so many perpetrators after the genocide that they needed a system that could deal with reconciliation and reparations, and how can these neighbours go back to living side by side when they previously were trying to kill one another. They needed a system to deal with that, whereas the UN didn't have the capacity to deal with that because it was dealing with just the most senior leaders who were the most responsible for orchestrating the genocide. So the two different systems of justice worked hand in hand. And it was good in a sense because the Gakaka courts had a real sense of local ownership, because it was
Precisely.
the local people who were involved in the dispute resolution, and it was the local people who needed ultimately to move past this horrible
Yes.
situation that had
So-
affected everyone.
You should read the study there, because Rwanda is one of the most successful examples of international dispute resolution, combining both, as Catherine said, the institutional framework of the UN and their little panchayats, because they realized that without that, even the institutional framework would only be effective to a certain point, not beyond. So it's a very good example of how two different systems of dispute resolution can work and should work together.
Can I add something?
Yes?
The issue is, the word I use, tension, is because Jirga is being considered as unconstitutional by the Supreme Court of Pakistan in 2019. That's
Yes.
why I asked.
What is Jug? Sorry, I don't know what that is.
Jirga is the council of the elder in our culture who decide the dispute among the people.
Okay.
It can be a property, a civil, criminal, even the criminal matter is being decided.
Okay. So if you're just asking me on the hoof, I take no view on whether if I was writing the law, I would consider it unconstitutional. But if it's unconstitutional and the government wants to explain what are the benefits, I can say the benefits of a more formalized ADR system is that often in community-based justice, the familiarity means that your independence of the adjudicator is potentially compromised. You need something much more neutral. And in terms of some of these questions that are being asked, they have broader repercussions than just the two parties before you. So there are certain types of, there's a certainty, there's a greater independence, and enforcement. Those are the things that I would perhaps emphasize if I was trying to encourage the community to adopt a different way of resolving disputes. But, you know, certainly the tradition I come from, they do encourage, if people want to resolve disputes in their own way, even down to religious communities. You know, there's different Islamic people that follow different strains of Islam, and a lot of those communities actually have very developed systems of dispute resolution that don't go to arbitration, mediation, or court. And the court, in English law, often endorses and supports that.
I was just wondering what the potential for a Pakistani in the UK job market is for high achievers with a local Pakistani degree or an external UK degree as well. Because a lot of kids actually and practitioners aspire to go to the UK. My impression is that there is no actually potential over there as well for someone who comes out of Pakistan, even with an external degree. Since you are on the ground, I would just like both of your perspective on that.
Well, look, thank you for asking that question. I was hoping someone was going to ask that. When I started in the law, obviously they call me a British Pakistani, but when I started in the law, there were very few people like me in elite law firms or elite chambers. And what's really changed in the last, I'd say, 10 years are two things. One is all the top chambers, commercial chambers, I'm not talking about criminal, and because that's not my field, they've always had better representation. Commercial chambers have never. You'll see every single chamber has suddenly taken on multiple Indian qualified lawyers, eminent senior counsel from India. That's one change, which is for the better, because in the sense that we have a more diversity, as well as trying to become more diverse. And a lot of the top law firms in England, in litigation and arbitration, are now directly hiring lawyers from Indian law schools. And that is a visible change that you see in litigation departments. So the question is, what can people do here? Because as far as I can see from the people we're working with, the top law schools in Pakistan are producing English-speaking, analytical, forensic students who are as good. And it's just a question of making sure that you keep yourself open and present to these law firms and say, look, if you're hiring from X country, we're also producing brilliant people, and you should consider us. It's just honestly opportunity, but that change has happened. If you go to some of the top arbitration law firms, just look at who they're hiring and look at their background. These are not people like me who were born in England and, you know, maybe considered British by them. It is people that are like yourself, but next door. And if you talk to them, they accept that we have brilliant lawyers here. I mean, I've just spent 3 days here. I've already been blown away by the young lawyers I'm working with, and our Kat was saying the same thing in the car. It's no surprise to us, right? You're doing the same thing. You speak English, you're forensic, and you're hardworking. And that actually, when you talk to the partners as to why they're doing this, what's changed, they feel that the more modern generation of lawyers coming through in Europe, other places, this is a big generalization. The hard work that you get from someone from India or elsewhere, or even Pakistan, is on another level. And so they're very attracted. And so you should be inviting these people to come and see what you're doing here, and I'm sure the routes will open up.
And
Once again, without any experience of English law at all, and they're still hiring
Yes,
out of India.
yes.
and
Because it's common law. So as long as you can go and do the professional qualification, you are as hardworking and forensic as, you know, someone else. But that is a big change in the last 10 years. I don't know if you've seen that.
Yes, when I first moved overseas to work in international law and arbitration, I went to Paris. And at the time I went to Paris, a lot of the big law firms had their main international arbitration groups based in Paris. And I didn't speak a word of French. And I thought when I was applying to firms there that I wouldn't be taken because I don't speak French. But in fact, the international arbitration groups in those big firms in Paris are full of people from all over the world, and they intentionally hire people from all regions who speak all languages because they need that diversity, because of the cases that they deal with come from all regions of the world, and they really want that diversity of input and diversity of backgrounds. And another good thing about the Paris firms, if you hadn't thought of it, is because the process to be qualified in Paris is different to London. In Paris, all of the French law students, they have to do these 6-month internships called stages. And so all of the law firms will often offer 6-month internships, and there's a higher turnover of them because more French students have to go through them, but it also means that they're open to international students as well. And often because there's a higher turnover and because the Paris firms want international recruits, they will take people for the 6-month internships, and they're often easier to get as international applicants than, for example, the training contracts in London where it's 2 years and you're competing against all the British students who want the 2-year training contracts. The 6-month one is really good because if you impress them in 6 months, they will often take you on as an associate straight away. So you don't have to have the full 2 years. And often some people will test out the firms in Paris. So if they don't like one firm, they might do another stage, another 6-month stage in another firm, and then got taken on there. And the international community of the lawyers who work in all these different groups in all the firms is very close. So you'll develop friendships with people who work in the international arbitration group in another firm, and you'll hear that they're hiring or they've got a case that's dealing with something in the region that you're familiar with or you have language expertise in. So it's a good sort of melting pot for opportunities, and it might be easier than some of the opportunities in England. And they don't expect you to have any English training because they are intentionally recruiting people from everywhere in the world. So that's something also to think about in case you hadn't thought about that as well.
Any other question? Yes.
Okay, so my name is
Introduce
Asad Khan.
yourself, please.
My name is Asad Khan, and I've been working with Nudrat last summer, and I'm from Government College University, Lahore, final year law student. I have 2 questions. The first question is a bit radical, but is arbitration helpful? Can it help us resolve a politically motivated issue such as the Palestine and Israel issue or the Kashmir dispute between India and Pakistan? And the second question is, can ADR truly dispense the desired justice? I see it as more about equity, because parties have to compromise, come to a common ground rather than as the core courts. They do deliver the thing, the right, differentiate the right and wrong, and deliver the thing to the person who kind of deserve it or who's the right.
Catherine, would you like to start?
Sure. So on the general question about whether arbitration can help resolve political disputes, I think it always depends on the particular dispute in question. But I have done recently an interstate arbitration between the UK and the EU over very political issues arising out of the Brexit agreement, and in particular fishing rights that's come up in the wake of that. And that has been extremely political in terms of the tension it's caused in the relationship between the UK and the EU. And both parties agreed to arbitrate that dispute. And it was arbitrated by a panel of arbitrators. One was a New Zealand arbitrator, one was from South Africa, and the third was French. And that process was an amicable way to deal with a very political dispute because it sort of took the heat off the politics of it, and the lawyers just dealt with the very legal issues that were coming out of the dispute. But that's a particular type of dispute that lent itself to arbitration because it was based on legal rights, and some other disputes might not lend themselves in that way. It all just depends on the political will of the parties involved, and what arbitration could offer in terms of dispute resolution. And your second question was about.
Can ADR like truly dispense the desired justice? Isn't it more about equity and like coming to a common ground rather than seeking what?
I think it depends if you're talking about mediation, which often is about finding a compromise that both parties will be happy with, whereas arbitration is typically more, it depends on the forum of arbitration and the rules that are being applied, but it's more often about applying certain rules to come to a binding outcome. And that is justice according to the rules, which might be an equitable outcome or not, but it's less of a compromise than mediation, for example.
Tariq, any
No, I
thoughts
agree.
on that?
Look, without going into the detail of either one of the disputes you mentioned, the Kashmir one and the Palestine-Israel one, I think those sorts of disputes are perhaps not as easy to envisage being arbitrated because I think there's an element of access to the public, so they should be able to come and see justice being done, especially if they're that political and everyone feels so strongly about them. You need a tribunal or the judge to have power to call witnesses and to make orders that are not always easy to do when you're just a bilateral dispute and you have a private arbitrator. And you may want other parties to make submissions, which again are a bit more difficult when you just have two parties fighting it out. So it needs to be more public, more transparent, and you need wider powers. So that often makes political disputes not great just to be arbitrated. I mean, I don't know, was your dispute in public?
It was
filmed?
It was public.
Yeah.
We agreed that it would be public, that
Yeah.
all the submissions would be made public.
Yeah.
But we had redactions for
For the documents,
sensitive
yeah.
things, so we had to take that into account.
So you're already seeing, even in normal arbitrations, some are in public because there's been a backlash that important issues are being decided secretly and in private, and that's really the case with certain political disputes. I think your view about ADR, you shouldn't generalize, I'm not saying you are, but ADR, if it's arbitration, is very capable of being as analytical and strict about, not strict, but black letter about resolving disputes as a court would. So it's not always just about equities. It looks like a court case. You have three very eminent people. So they can sometimes be, and often are increasingly, former judges, and you have lawyers on either side fighting just like they would in court, making complex legal arguments or factual arguments, and then you have an award that looks like a judgment. And it's not based on what I think is fair. So I don't think it's true that it's always about equities. It can answer binary, or it can answer questions that are difficult.
I think, Asad, initially when ADR as a concept began, it was alternative dispute resolution, and arbitration was a part of it. But because arbitration developed a legal framework and rules, and then that was aided by the New York Convention for the Recognition and Enforcement of Arbitration Awards, arbitration then developed independently as an institution, and ADR came to denote much more softer methods like mediation or negotiation. And so that's when you're thinking of compromise, it's more on those grounds.
Yeah.
But in fact, arbitration developed so much that now the complaint about arbitration is that it's too much like litigation.
Yes.
As expensive, as long and protracted. The only advantage is that it's confidential, so it's not public, but even that, as we heard in different cases. Just to, on your point about big political issues, there is a whole movement on conflict resolution and post-conflict arbitration. And so I think the example that Catherine gave is a very good one, that sometimes you can have very sensitive stakeholders like England and Brexit, but the subject matter of what you're arbitrating can be very non-political, like fishing. Or so this topic came up in Saudi Arabia recently, where the Saudis said that because of the conflicts currently happening in the world, businesses are suffering. So can we utilize the system of arbitration or ADR to focus not on uniting people or resolving geographical, territorial, ethnic disputes, but amongst those people take on business or commercial disputes and just use the system as a procedure to resolve those disputes without going into the politics of it. So there is a movement to do that.
Can I?
Yes.
I was just going to add one final thing. Is there, if you're interested, there is a famous conciliation of a political dispute done under the United Nations Convention on the Law of the Sea between Australia and East Timor. And that was a conciliation over effectively access to transboundary resources. And so that I think is the first, or in very modern times, the first interstate political dispute that has been successfully subject to conciliation, actually. So not even arbitration, it was a conciliation method under a treaty, and that has been quite successful. And so there in recent times has been a push towards, can we have more of these conciliations? But again, it depends on the type of disputes and the types of issues and the political will involved, I think.
Manal, who will have the, oh yes, I think Manal was first, and then in terms of, we follow the letter of the law first.
My question to Ms. Catherine is, what's the difference between an interstate arbitration and a commercial arbitration?
That's a good question. So an interstate arbitration is where both parties to the dispute are states or governments of states. And a commercial arbitration is an arbitration where both parties to the disputes are often commercial parties, so companies. But sometimes you can have a commercial arbitration where one of the parties is a state or a state-owned commercial entity. But the issues that are being decided in the commercial arbitration are usually about a contract. So commercial issues decided according to contracts governed by domestic law, whereas interstate arbitrations between two states are governed by public international law. So the rules that govern how states deal with one another.
Thank
May I clarify my question? My question is there any procedural difference between the two arbitrations, or are they both in the procedure same?
Oh, right. Sorry, I misunderstood the question. So interstate arbitrations are ad hoc or subject to specific treaties between those states. So the common rules that we know for international commercial arbitration, so the LCIA rules, the ICC rules, even the ICSID rules for investment treaty arbitration, those rules are sort of standing rules that states can use. For interstate arbitrations, there's not so, they wouldn't use those rules. There are some standing rules. The PCA, for example, has some standing rules that states can adopt, but often they would agree their own specific rules. So in the fisheries arbitration I mentioned, the UK and the EU, under the Trade and Cooperation Agreement, which was one of their main Brexit agreements that managed their post-Brexit rights, they incorporated a chapter that dealt with the procedure for arbitration. And they can make it whatever they want because they've got freedom to contract. So in this case, they decided that they would have the whole arbitration be started and finished within a 3-month period. And that was the wrong decision from the perspective of counsel, who has to deal with lots of scientific evidence about fishing and what is the best available science about fishing practices and whatnot. The procedural differences can be whatever the states decide vis-a-vis these other well-known commercial rules.
Please introduce yourself, please.
My name is Samad Zafar and I'm from Team and Associate and he is my teacher. And I thank Punjab Bar Council for arranging such a beautiful event for giving us the opportunity to be inspired. And my question is from Mrs. Catherine. And I was actually listening to your earlier discussion about the organizational skills that advocates must learn. And I would like to learn what part can advocates take so that we can actually learn better organizational skills. If the format is only listening, I think it won't help students like us. Would you like to
Excellent. Yes.
Okay, good question. So practical skills to learn to have good organizational case management practices. So everyone would have different preferences, so I can speak only from my own experience. But I, for example, do things like, if I get a new case, I will separately create a timeline of the key events. So the dates that the events happened and the events themselves in a table sort of format. And I find that doing that, even though I can read all the documents and I can sort of keep the timeline in my head, if I've created a separate timeline, it often helps me see connections that I wouldn't see if I was just reading the papers, which might not be in chronological order. And that can be really useful for figuring out connections and figuring out arguments. I also will sometimes do depending on the case, I sometimes will do sort of a responsive table. So I will do a table that has all the paragraph numbers down one side, and I will put my reactive, sometimes I'll copy the actual, depending on how long the pleading is, from the other side. I will copy the paragraph into one column of the table, and in the next column I will have all my notes about my reactions to that. Because even though I can highlight on the document, often I will have so many thoughts about even just one particular paragraph or one particular phrase in a paragraph. I find it really useful to keep all of my thoughts organized in that way, and then I can always come back to it if someone says, oh, what did they say in paragraph 404? Don't you think it's interesting? And I'll be like, actually, yes, here are all my notes that I've previously thought about that. So I find that really helpful as well. I really love color coding. I love highlighting and tabbing, and anything that I can do that will help me organize the information in my head in a useful way. I often will write notes to myself. So I will write notes to myself as if I had asked myself to write a briefing note on the possible legal arguments and the strengths and weaknesses of them on a case, so that I have it just for my own benefit, and then later when I'm working up the arguments I can refer back to that, or I can do further research on certain points. And I will, in that sort of document, that note to myself, I will keep notes of things that I have to do. And often there will be lots of things to do, like exhaust research on this point, see if there's any precedent on this point, cross-check against that other contract that I read 2 weeks ago that I think said something relevant. And then I'll go back and I'll cross off all the things that I have done, and I'll feed in the answers into my other analysis tables that I've got going on. So it depends really on the type of the case, how much time you've got to do the analysis, and what works best for you to organize the information in a way that will help you be really methodical in analyzing what are the possible legal arguments, what are all the strengths and weaknesses of those arguments, what's my response to the weaknesses of the arguments. If I got questioned in court, what would my response be? And also that analysis helps me work out how far can I take an argument? When do I have to concede? What is going to look reasonable? What is going to look unreasonable? And what is the best way to get from where I am now to the outcome that I want? Because often, if the outcome that you want can be achieved with only winning 1 or 2 arguments, you might not want to run 10 arguments. If 8 of them are fairly weak and you might lose on them, but you have 2 really strong arguments, you might decide just to run those two strong arguments, because that will make you look more reasonable to the judge. The judge won't have depending on the judge and depending on the case, the judge might not take very kindly to you running all these weak arguments. It might look like the judge might assume that all of your arguments are weak and then not pay attention to your strong arguments. So it helps in sort of devising the best strategy for a case and making sure that you can track your own thinking as to the strengths, the weaknesses, the strategy, and why you took decisions that you took in case you need to come back later in the case. If it's a case that goes on for a long time, I understand. I don't have all that much familiarity with how long cases take, but the cases that I'm involved in, they take a really long time. And so it's always helpful, as I said before, to be able to go back and think about why did I make this decision, and I can see the analysis behind it.
Tariq, what are your organizational secrets?
I do. I think less is more, but that doesn't mean I do less note taking. So, for example, when you're going to meetings, don't create a new document each time. Just have them in date form in one document, because often when your case gets longer and longer, and you've got 25 subfolders and 100 documents within, it doesn't really need to be like that. I always do a table, a bit like what Kat said, 3 columns or 2 columns. One is the proposition in the pleading, and then my response to it, ideas I've got, further questions I have. Further questions and further research is highlighted in yellow. Red is things that are really I'm worried about, so I want to just... Green, good helpful facts or points. And then light blue, if it's closer to the hearing, because now that I'm a silk, I don't do this from the beginning, I do it closer to the hearing. Turquoise is for cross. So I'm cross-examining the pleading and just putting my ideas down. No, not everything has to be color-coded. There'll be things that aren't, but that second column is very important. And frankly, when you do that, it's a way of internalizing the ideas and the thinking and the connections. Yeah, so I do that. And then that's really the main basis. I like to do a full note of what I'm reading, just so I can get to the bottom of it.
I have a follow-up question actually. Earlier, Madam was talking about getting into a mentality of not presuming what we think is true. So how we get into that mentality?
I think, it's you're starting by, if I'm the first person who's ever said that to you, then this is the start of trying to get into that mentality. I used to talk a lot to lawyers and other students and people that were practicing, and I think I annoyed people, but it was a really good way of getting into how people think. And ultimately, the more you do that, because you can't just one day decide I'm going to be analytical or I'm going to question myself, but always every single interaction you have is a form of advocacy or an exchange, how you're trying to persuade people. They used to teach rhetoric many, many hundreds of years ago, and that was the art of persuasion, the art of constructing an argument. So this is not just a law thing, it's how you are every day. And if you don't get something that you wanted, or you got something that you wanted, it's always interesting, well, what did I do, or what did that other person do to get how they got where they got? And constantly inquiring or thinking about these things will inevitably make you a better person. But it will also, there is no way that if you did that, you don't come away thinking that you don't have all the answers and that you can't just be about your best case, that you have to listen to the other side and then put yourself in the judge's position. Someone who comes in and makes out that their case is perfect and there are no holes in it is just impossible. Life does not create such perfect disputes that everyone is right on one side or the other. So if you're presenting a dispute like that, I bet you the judge is thinking this is too slick. There is no way that this is so clear. So you've got to give, if you can, give a concession, present it, almost say, look, there may be a difficulty here, but I'm telling you why my interpretation is a more sensible one given these other factors, right? Even pitching it affects the way you pitch a case. And if you talk to judges and arbitrators, they don't like people who are either overly aggressive or just act that there is absolutely no doubt in their case and go too far. Sometimes you meet clients from the business world who think that their way of arguing, their rhetoric, works in law, which is, I'll ask for 100 million and I'll get 50. Actually, if you do that constantly, you lose credibility, right? So it doesn't work in the legal field. But then our approach probably doesn't work in the business field. So you've got to constantly be asking how are things being structured and why.
Thank you very much. I think, Javeria, one last question and then yes.
My name is Javeria Khalik.
Very nice
I'm also doing law from JCU.
Yeah.
I had opportunity to intern with Barrister Nudrat Majeed. So my question is from Sir Tariq Baloch, and the question is, how does the courtroom advocacy in England differs from the other jurisdictions, for example, Pakistan, in terms of legal strategy? How would you differ it from the
Well, I've never appeared in court here, and I would fail miserably. And I'm obviously a practitioner from England in the courts, but I don't go to other courts. But I see how practitioners from other parts of the world operate, and their way of advocacy. Again, we have to be open how other people do it. It's not because our way is this way is better or their way is better. It's a function of the kind of people that you're trying to persuade. If you're trying to persuade someone who hasn't read your skeleton as a judge and is not prepared and is willing to adjourn, then that will impact your advocacy and how you're, even from before you get into court, because the way you're jostling to frame your case. What I have found, I don't want to be Pakistan specific, but some traditions, they are having to fight in a system where the tactical and procedural ways of shutting down a case are so effective that they forget about the substance. That is not their fault. That's the system they're in, and so I see why coming up with that gotcha moment procedurally is very important. In England, although it used to be like that, it's less and less like that. Substance is important, and we have very few adjournments. It's very, very hard to adjourn a case. And I was telling, I think Nudrat or someone else, that when we bring a case in England in the courts, you're supposed to give an estimate of how many days the case will take. And that estimate now has to include the reading time for the judge. So if you say 4 days, you have to say 1 day reading. And you can't just say, oh, this sounds like a day. You have to be very precise. You give them a reading list. And if you've got your reading list wrong, they will admonish you when you get into court. What does that mean? It means everyone has certainty. The court knows this is going to be 4 days, including reading time, so they know what judge is free, has the 1 day. It will be 3 days, come what may. It doesn't matter if you have 50 other arguments to make. It's going to be 3 days. They may say, okay, part heard, I'll give you another day, but broadly speaking, and you have certainty because you know my skeleton has to go in a week or a few days or whatever before, and we swap. And so I don't have to worry too much about how can I adjourn this or are there other tactics I can use. I know that I have to give a 25-page skeleton. If I really push, I may get an expanded page limit, but that's again, they don't like that. They think that you should be able to put your argument down in 25 pages, no matter how complex the case, and then you go into court. And you will have a judge who most of the time has read the skeleton, they've probably read the key documents, and then you normally start by saying, this is how I'm going to structure my submissions. And that's not just form, it's so that the judge can say to you, I don't need you to tell me the first 3 things, I've read everything, can you focus on the last 2? So it's a sort of collaborative process of advocacy. Now, if you don't have that system, and you're not even sure the judge has read your papers, and in some because they're so busy, not because they're not diligent, but they've got 350 cases or whatever it is, it's a very different exercise that you're going in with. You may want to then focus on headline points. You may not be able to get analytical. The client may be upset because they're facing this. So those are, just some examples of the different traditions. That's not Pakistan specific. I've never practiced it. So.
Okay, we have one last question and then yes, Mariam.
My name is Mariam Javi,
Yeah.
and I am an associate for Law for Chambers. I would like to ask that has your approach been changed after the introduction of artificial intelligence in the field of law?
Why don't you answer that? I'll give an answer too, but you go for it. Yeah.
Well, I recently have started trying to use AI a little bit as a little helping hand. I would never rely on AI for anything. I would never just put something into AI and then put it in a pleading or not check it, not at all. So I first started using AI for factual research, so publicly available information, summarizing, for example, I'd put in the name of a company that might be related to a dispute I'm working on, and I'd say, where in the world is this company working, and summarize what their main projects are, or something like that. Or if I was looking for an arbitrator for a particular case, I'd say, what arbitrators have civil law backgrounds, but also experience in, for example, the wind sector. And so then it would find all the information on the internet for me about that. Or I'd use it for foreign language research that I couldn't do. So I'd say, search in the Czech language on Czech websites for information about this. So it was very helpful for that. And then I started, I got access to the Westlaw now has an AI platform, and Lexis now has an AI platform. And that is, they are much better than, for example, ChatGPT or some of the other public ones, if you want to do case research to say, are there any relevant cases on this issue, or summarize the law for me on this issue. So ChatGPT and some of the other public ones sometimes make up cases, and they've done it to me, or they've made up quotes from cases, and it's annoying because then you go and check it and it's wrong, and you always have to check it. But some of the, if you are lucky to have access to some of the database ones, they are better because they have built-in safeguards so that they can't make things up. And it is a good shortcut, but that's all it is. It's just a shortcut. You always still have to do the legwork. You have to check everything. You have to make sure that you don't rely on it too much. And it's really important, I think, if you are using it, to really take seriously what it is that it's giving you. Don't think critically about what it's giving you, because I think that some of the AIs are trained to sort of tell you what you want to hear. So if you say, are there any cases on X, or isn't the position on this Y, it might have an inbuilt bias to tell you what you want, rather than saying, no, you're confused about that, that's not how it works, this is how it works. So you have to be really critical with what you're asking it, with what it's telling you, and you really need to check everything. But it hasn't changed my approach all that much. I'm just trying to use it as a bit of a shortcut when I'm busy. And I think in the law, there's so much judgment and analysis and strategy that goes into every aspect of a case that it would be difficult, I think, to rely too heavily on AI for anything. But we're early days. Maybe it's going to wow me and it's going to put me out of a job. Who knows?
So I've seen more and more juniors use it. They've given me examples. So you could have a legal question and say draft a skeleton, and it actually drafts a skeleton. It's not always very good, but if you find writing hard, then it gives you something. But I can't emphasize enough the things that when I've experimented with it, it doesn't have an idea of weighting sources. So to give the example of fishing or something like that, or you say, give me an arbitrator who has fishing disputes experience. If it finds one, it would make out that person is very experienced, when actually one source or one case doesn't say very much. Or they've written one article and they'll be described as a leading expert. Again, that doesn't mean anything. So the sources are very important. It does make up cases. There's enough coverage about that it makes up sources, makes up quotes. So I really, that is very worrying. So as Kat says, keep checking, but also you must embrace new technology. There's a lot of wastage and churn in the practice of law, which I think for clients and consumers makes it much more expensive than it needs to be. Getting someone who's a full-time lawyer to be checking footnotes and rationalizing stuff, or even summarizing information, that's hours and hours of money that a client is being asked to spend, which could be done very efficiently by new technology. So I think we should embrace it, but we should know, we should keep in mind that some of these things I just said are also important to develop as a good lawyer, knowing what is good to summarize and what not. And also just to keep in mind that you need to know how to search for things yourself. Yeah.
So it's a good, I think we'll end now. If any questions, you can ask informally.
Yeah.
Just to end on what we began. When we began, we said that education and learning is something that requires an investment. And here we end on the fact that if you are going to use AI, spend money and get something that has protection and is part of an institution. So there are legal websites and you can do that. But that is a good investment rather than relying on public open AI or like Perplexity. Or DeepSeek or ChatGPT. So and there is no shortcut. There is absolutely no shortcut, so don't rely on that. Qayyum Saab, would you like to come and give any closing remarks? And thank you for your patience. They were really good questions and comments, and I'm sure the speakers enjoy. I learned a lot. I hope you also felt the same. And what a privilege that they were here for a short time, but they made the effort. So thank you to both of them.
Thank you.
Thank you, Nudrat. Yeah.
It's a bit late in the evening, so I won't take too much of your time. I will just point out to all of my friends that whatever was presented before you is possibly of a different level as what we experience here in Pakistan in our practice. Most of actually what was discussed here, but this is something we can aspire to. So this is a level of excellence that we normally do not unfortunately find here in Pakistan. Even though once again it is something that we aspire to. We would like to we are very, very thankful to Madam Nudrat for giving us access to our friends who have shown us aspects of a different system, things that we can improve about our system as well. And as I said, something that we can aspire to. So, sir, thank you very much for your time, and it was indeed a pleasure and an honor.
Thank you.
Thank you very much. Yes, please, let's do it.